Okay, good evening and welcome all of you to this special Georgetown Law lecture, Violence Against Asian Americans, What Legal History Reveals, to be delivered by one of the nation's preeminent scholars of Asian American legal history and criminal justice, Professor Gabriel Jack Chin, the Edward J. Barrett Jr. Chair of Law at the University of California, Davis School of Law. I am a proud member of the Asian American community. My parents immigrated to the United States from India in 1969, and I was born in New York City the following year. Our Asian and AAPI students, alumni, staff, and faculty are cherished members of the Georgetown Law community. The Office of Graduate and International Programs, where I serve as the Associate Dean, invites over 200 students from countries in Asia each year to join our global community as students and later as alumni. We and the Law Center as a whole have many members of the AAPI community in our programs as well. In the entering JD class, Asian and Asian Americans often comprise some 12 to 15% of the class. I'd like to thank the co-sponsors of this event, the Office of Graduate and International Programs, with special thanks to Assistant Dean Tiffany Jolie, who makes everything possible. And thank you to our other co-sponsors, the Asian Pacific American Law Students Association, shout out to APALSA President Isabel Yu, and the Asian Law Center, shout out to Center Director Tom Kellogg. I would also like to thank Olivia Jalitz and Chris Hammer from Special Events, and Deborah Gallus and Jonathan Wynn, who helped make this event, who are helping to make this event all run smoothly with incredible patience. Tragically, the COVID-19 pandemic has given rise to heightened animus toward and violence against Asian Americans, in particular against women, girls, and the elderly. As leaders, including former President Trump, blame the virus on China, Asian Americans are increasingly falling victim to violent crimes. In San Francisco, an 84-year-old Thai American died last month after being violently shoved to the ground during his morning walk. In Oakland, California, a 91-year-old senior was shoved to the pavement from behind. In Brooklyn, New York, an 89-year-old Chinese woman was slapped and set on fire by two perpetrators. A stranger on the subway in New York slashed a 61-year-old Filipino American passenger's face with a box cutter. And tragically, the whole world is mourning the killing of 6 Asian American women in Atlanta last month. Research released by reporting forum Stop AAPI Hate recently revealed nearly 3,800 incidents of hate crimes against Asian Americans reported over the course of roughly a year during the pandemic. This is significantly higher than the previous year's count of about 2,600 hate incidents nationwide. Asian and Asian American women made up a far higher share of these reports at 68% compared to men. And according to a brand new Pew Research survey, today, 1/3 of Asian Americans fear someone might threaten or attack them. And this is a higher percentage than that reported by any other racial group. As a result of the insecurity these incidents have created, community members in cities like Oakland, California are creating safety patrols to help protect their community members. This campaign of terror against Asian Americans comes at a time when Asian Americans are the fastest growing racial or ethnic group in the US. Numbering more than 20 million, the Asian population in the United States is a diverse group with origins from more than 20 countries in East and Southeast Asia and the Indian subcontinent. And yet, a continuing source of violence against Asian Americans is the lingering belief that Asian Americans are and always will be foreign. As one Asian American put it, "I'm Asian, so I can never be American." We are most fortunate to have with us today one of the nation's leading scholars of Asian Americans and the law to give us a broader historical context of the treatment of Asian Americans in the United States. Professor Chin will address whether this recent spate of attacks on Asian Americans is an anomaly or a continuation of a long, unfortunate history. Our distinguished guest holds the Edward J. Barrett Jr. Chair of Law at the University of California, Davis School of Law. Professor Chin is a teacher and scholar of immigration law, criminal procedure, and race and the law. He is a prolific and highly cited scholar. His articles have appeared in the law reviews of Yale, Penn, Duke, UCLA, Cornell, Georgetown, and countless others. The US Supreme Court has cited Professor Chin's work on numerous occasions, including his work on collateral consequences of criminal conviction in Chaidez v. US in 2013, and in Padilla v. Kentucky, 2010 case, which agreed that with his contention that the Sixth Amendment required defense counsel to advise clients about potential deportation consequences of guilty pleas. Justice Sotomayor cited his Penn Law Review article in her dissent in Utah v. Strife in 2016. Notably, Professor Chin also works with students on legal reform projects. His efforts with students to repeal Jim Crow laws still on the books includes a successful 2003 petition to the Ohio legislature to ratify the 14th Amendment 136 years after the state disapproved it during the ratification process. Professor Chin and his students also achieved the repeal of anti-Asian alien land laws, which were on the books in Kansas, New Mexico, and Wyoming. For this work, A Magazine named him one of the 25 most notable Asians in America. In connection with classes with a practical component, he has tried felony cases and argued criminal appeals with his students. He serves as the faculty director of clinical programs at the UC Davis School of Law. It's a particular delight for me to welcome Professor Chin to Georgetown Law today, as I had the great pleasure of being his colleague at UC Davis. We will invite you all to join us for some Q&A at the end of Professor Chin's remarks, and you can also add your questions here. But without further ado, I would like us to welcome Professor Jack Chin.
Thank you, Dean Sunder, for that very gracious introduction. It's a real pleasure to be here. Georgetown is a special place to me. I admire the work of so many faculty members here, and I miss the former UC Davis faculty members who have gone to Georgetown. And I also really appreciate having had the opportunity to work with students on the Georgetown Law Journal and the Georgetown Immigration Law Journal over the years. I am not going to try to explain the terrible things that have happened in our nation recently, but I do want to provide some legal context for these tragic events. I'm going to share my screen. As Dean Sunder mentioned, we've had an outbreak of hate incidents related to the COVID-19 pandemic. Thousands of incidents have been reported. In surveys, huge numbers of Asian Americans say that they've experienced street harassment and that they fear street assault. So this is something that's going on around the country. And from a strictly logical matter, the question arises, why are Chinese Americans targeted? Okay, some people blame the Chinese Communist Party or Chinese scientists for the invention or the dissemination of the COVID-19 virus, but the Chinese Americans here in the United States had nothing to do with that. We're here in the United States. We're not the ones who brought the disease over from China, most of us. We're not scientists or Communist Party officials in China. We're Americans. And I think the answer for that, the explanation for that, is this concept of perpetual foreigner. That for Asians in particular, there's an inevitable, unbreakable, permanent connection between racial ancestry and the homeland. No matter how long a Chinese person has been in the United States, a lot of people are going to look at that person and say, there's some that you are associated with China, even though for someone like myself, I've never been to China. Nevertheless, there's that association. From a logical perspective, okay, even if Chinese Americans are permanently associated with China, why are Thai people, Filipino people, other non-Chinese Americans being harassed and attacked on the street? And I think the answer is that there's also this idea that all Asians are the same. No particular difference. And I want to talk about where these ideas came from, how the law, American law, built these ideas. I'm going to begin with the point that the cluster of ideas surrounding Asianness, surrounding Chineseness, has always been multifaceted. This is a cartoon from a satirical newspaper, The Wasp, published in 1881, during the time when Chinese exclusion was an important political issue in the United States. And this is obviously a mock Statue of Liberty. And I hope you can see that liberty here, Chinese liberty, it has their foot on the skull of a person, presumably a white person whose life is harmed by having Chinese in the United States. An opium pipe is in hand. And the crown reflects a cluster of ideas. Ruin to white labor. So there's an economic problem with Chinese coming to the United States. Disease, immorality, and filth. At the time this was happening, Chinese were being blamed for bubonic plague outbreaks in San Francisco and Honolulu. The problem of Asians in America didn't begin in the 1880s, though. It goes back a lot farther. There's a question, a debate, which is ongoing to this day, about whether the US Constitution, the fundamental law of the United States, protects slavery. The abolitionist William Lloyd Garrison said in a speech once that the Constitution was the source and parent of all the other atrocities, a covenant with death and an agreement with hell. He then burned the Constitution and said, so perish all compromises with tyranny. Frederick Douglass, who, with a little help from his friends, freed himself from slavery and became a major anti-slavery activist, thought that the Constitution was the solution to the problem of slavery, and that the Constitution didn't protect slavery, but to the contrary, created a series of ways in which slavery could be ended. And so this debate goes on to this day about whether the fundamental document of our nation is racist. I don't have the answer to that question, but I do want to propose to you that there is no question that the framers of the United States conceived of this country as a white nation. This is the Naturalization Act of 1790, one of the first acts of the first Congress. It was signed in their then capacities by the first three presidents of the United States. And it limited the ability of a person to become a naturalized citizen to free white persons. I believe that when white supremacists say that this country was founded as a white nation, they have a point. The racial restriction on naturalization was in effect in one way or another until 1952. It was recognized as a central foundational principle of United States law. In 1922, a unanimous Supreme Court called the racial restriction a rule enforced from the beginning of the government, a part of our history as well as our law, welded into the structure of our national polity by a century of legislative and administrative acts and judicial decisions. Now, obviously, history tells us that the Naturalization Act of 1790 was about Africans, at least. They were not allowed to become naturalized citizens. It plays an important role in Dred Scott versus Sandford, where the Chief Justice said many things about the status of Africans in this country that are notorious to this day, that they had no rights, which the white man was bound to respect. And one of the grounds for Chief Justice Taney's controlling decision in Dred Scott was the Naturalization Act of 1790, which he said shows that citizenship at that time was perfectly understood to be confined to the white race and that they alone constituted the sovereignty in the government. Now, does the Naturalization Act of 1790 have any application to Asians? Does the rule or the principle of Dred Scott have any application to Asians? It turns out, I think, that there is an answer, and it comes from another decision of Chief Justice Taney when he was trying a case as a circuit justice in the District of Maryland. And he had a defendant, Lorenzo Dow, who claimed that he should be treated as a white Christian. 17 years before Dred Scott, this is 1840. And Chief Justice Taney responded to Lorenzo Dow's claim that he should be treated as a white Christian by exploring the political history of the colonies. And he said that the colony of Maryland was founded by white Christians, and any other type of person, a non-Christian or a non-white, would not be a welcome or equal addition to the colony. They would not be treated as a member of the political community. And Chief Justice Taney said, as the slide says, the only nations of the world which were then regarded, or perhaps entitled to be regarded as civilized, were the white Christian nations of Europe, and certainly immigrants were not expected or desired from any other quarter. Now, Lorenzo Dow was not African. He was not Indian, which was the other race that was dealt with in Dred Scott. He was, in the racial categorization of the time, a Malay. He was a Filipino. He was Christian, but that wasn't enough. He wasn't white, concluded Chief Justice Taney, so he wasn't entitled to be treated as a white Christian. The opinion noted that Malays were subject to enslavement in the Maryland colony, and therefore, as an Asian from the Philippines, he wasn't a member of the race of which the masters were composed, is the language that judge used in that case. I think of him as saying the Asians weren't part of the master race, and so the court ruled. So when 17 years later, Chief Justice Taney decided the Dred Scott case, and he said that citizenship was, at the time of the founding, perfectly understood to be confined to the white race. I think he intended to exclude Africans from equal participation as citizens, but also Asians. In this period before the Civil War, there was a political problem, a practical problem that the government faced. And that is that they wanted to encourage white immigration. Here's another Supreme Court justice talking about his understanding of the policy. Christian foreigners of our own race are encouraged and invited to convert these wastelands into productive farms, wasteland being what I would call Indian property. But the rights of non-whites were curtailed. How to protect the rights of whites and curtail the rights of non-whites? Well, one thing that happened in this period was the development of the Declaration of Intent. And the Declaration of Intent was a process, a step in the naturalization process that was in effect from 1795 to 1952. And it was a court paper that a person could fill out the very day they arrive in the United States from another country. When they filled out this paper that said they intended to become a citizen of the United States, they would be what is known as a declarant alien or a declarant non-citizen. And they would have a certain kind of status. But of course, if one was ineligible to ultimately become a citizen because they weren't of the white race, then they couldn't validly file a Declaration of Intent. And so what the Declaration of Intent did is give the declarant most of the rights of citizenship. Here, for example, is the Donation Land Act of 1850, which applied to the Oregon Territory. The Oregon Territory comprises what is now the states of Oregon, Washington, Idaho, and parts of Wyoming and Montana. The Donation Land Act was a predecessor to the Homestead Act, and it gave away free land to certain people. And in some ways, the Donation Land Act is progressive. For example, it gives more land to married couples, and the part of the land that is attributable to the wife is, if you look at the last line of this slide, to be held by her in her own right. So the historical discrimination against women with regard to owning property is eliminated in this law. Certain other restrictions, though, are not. The Donation Land Act applies only to white settlers or occupants, American half-breed Indians included, and it gives the free land to citizens or declarants. Declarant aliens are welcome to participate in this free land to carry out the policy Justice Greer described of encouraging white immigration. In addition to the free stuff, declarants were often also given the right to vote. So here, for example, in the Oregon Constitution of 1857, white male citizens, 21 years and older, can vote, but also white males who have declared their intention to become a citizen. Unless there be any misunderstanding, in Section 6 of the Oregon Constitution, undesirable races are not allowed to vote. Part of the consequence of conceptualizing the people of the Oregon Territory as being people of a particular race was a racial restriction on property ownership. And this is something that's pervasive in the pre-war period. The Oregon Constitution prohibits Chinamen who are not resident of the state when the Constitution was adopted from holding a real estate claim or a mining claim. Another characteristic of the legal situation of Asians during this period was testimonial disqualification. This is the California statute that prohibits an Indian or Mongolian or Chinese from testifying in a case involving a white person. This traces to slave law. Enslaved people, of course, could not testify against their masters or also for their masters. And what I want to suggest to you is that not being able to testify is a terrible burden, because basically it means you can be raped, robbed, or murdered with impunity. And if there are no white witnesses who are willing to testify for you, then there's absolutely no legal recourse. So then there's another major development, Reconstruction. A series of civil rights acts, a series of constitutional amendments change this situation with regard to race relations in this country. Some of the Supreme Court's affirmative action cases describe the implications of the Reconstruction laws in very broad terms. 14th Amendment's designed to do away with all governmentally imposed discrimination based on race. Designed to eliminate racial bigotry as an evil to be stamped out, say some of the justices. And this might be the best interpretation now. If we look at the Constitution as a living document, this might be the interpretation that we as a society would want to adopt. But it's entirely divorced from the history of the Reconstruction Amendments. In terms of what Congress thought they were doing at the time, it's completely imaginary. There was a set of proposals to do what some Supreme Court justices said actually happened. Senator Charles Sumner proposed, for example, that immigration and citizenship and every other aspect of civil rights law simply be made race neutral. But his ideas were basically non-starters. It didn't happen. What ultimately happened is that the Reconstruction laws were designed to solve the problem of the African-American situation, but not go very much further than that. For example, with regard to the Naturalization Act of 1790, which limited naturalization to free white persons, Charles Sumner said, let's just make it race neutral. Let's just take out the word white. And that was a complete non-starter. And ultimately what Congress did is that it added the words African nativity and descent. So persons of African nativity and descent, in addition to white persons, could be naturalized. But there was no willingness to let Chinese be naturalized. That was a deal breaker for that proposal. The 15th Amendment. 15th Amendment's one of my favorite amendments. It's a good amendment. It is, however, a Jim Crow law. Unfortunately, that's the truth. Why doesn't it just say that the right to vote shall not be denied or abridged on the basis of race? Why does it say citizens of the United States can't be discriminated against? And the answer is declarant voting and non-citizen voting. Congress decided to allow the states to discriminate in who they allowed to vote on the basis of race among non-citizens. So states could pick and choose, and statutes like this, where Idaho says Chinese can't vote, Indians can't vote, perfectly constitutional under the 15th Amendment because it applies to non-citizens. The decisions of Congress during Reconstruction to allow discrimination included a choice to allow discrimination in land ownership. The Civil Rights Act of 1866, which is now codified at 42 U.S.C. 1982, like the 15th Amendment, prohibits discrimination in land ownership only among citizens. And so California's the decision here to allow certain non-citizens, certain races of non-citizens to own land and others not, was one that the framers of the Reconstruction Amendments decided to allow. So we have a situation where Congress has left the door open for various sorts of discrimination, even after the Reconstruction Amendments. And after the Reconstruction Amendments, Congress turned to immigration regulation. Before and during the Civil War, the borders were open, at least at the federal level. There were some state restrictions, but there was no federal law that said who could come or who couldn't come to the United States. No passports, no visas, just walk in. That changed for Asians. What I think of as one of the first modern immigration laws, perhaps not the first, but one of them was the Coolie Act of 1862. And the coolie trade was a form of the slave trade that involved Chinese laborers going to Cuba and other places, and it was cruel. And it was, I will grant, a humanitarian decision of the United States to try to suppress the coolie trade. But they did so in a way that began the process of regulating Asian immigration to the United States. I think the Coolie Act invented the visa. And basically what Congress did is it said no ship headed for the United States with Chinese people on it can land unless they have a certificate from US authorities in the place where the ship came from. So previously, free trade. After that, Chinese coming to the United States have to be inspected before they leave. Inspected for a good purpose, to ensure that they're coming freely, but nevertheless, it's the beginning of immigration control. Next major step, the Page Act of 1875. And the function of the Page Act was to deem Asian women presumptively prostitutes. It applied to people coming from China, Japan, or any Oriental country. Once again, Asia being treated monolithically, no difference. We then have the Chinese Exclusion Act of 1882. It's strengthened over time. As other Asian groups begin to immigrate, they are also subject to exclusion laws. Japanese immigration was dramatically restricted through the Gentleman's Agreement. Asian Indian immigration was restricted through the 1917 Immigration Act, which drew a triangle around continental Asia and said nobody from there can immigrate. And finally, in 1924, Asian exclusion was perfected by linking the right to immigrate to the right to naturalize. And so the 1790 Naturalization Act, which limited naturalization to free white persons and persons of African nativity and descent, was made a requirement for immigration. You couldn't immigrate unless you could naturalize. So all non-white Asians were excluded. And this policy was in effect in one way or another until 1965. The story of the rise of the Chinese Exclusion Act, the development of the Chinese Exclusion Act, is one of violence. This is a lithograph from the Rock Springs, Wyoming massacre, where in 1885, at least 28 Chinese were killed by miners who wanted them to leave the mines. And there are dozens of expulsions in this period of Chinese throughout the West, as far north as Alaska, many in California, but also in the interior of the United States. And whites, often immigrants, insisted that they had the exclusive right to work in particular places or to live in particular places. And oftentimes they had the courtesy of warning the Chinese that if they didn't leave, they would be killed or burned out. But many were expelled from the Pacific coast. Now, the United States fancies itself as a country that's dedicated to the rule of law, to law and order. But the response to the ethnic cleansing of this period was kind of like the response to lynching in the South. It was widely understood as an expression of community sentiment that demanded attention, that demanded response. And it didn't lead to arrests and prosecutions of the people who committed these crimes. It led to a decision that the Chinese in this country were a problem, that they were inducing violence, that they were inducing disorder that required more restrictive immigration laws against their presence. And so in 1888, after a wave of this violence, Congress passed a law that tightened up the Chinese Exclusion Act in a variety of ways. And one of the things that it did is that it said that return certificates, which were issued to Chinese people who left the country to allow them to come back into the United States, notwithstanding the Chinese Exclusion Act, were invalid. And they were invalid, they were voided retroactively. And so people who had left the country and were still out of the country in reliance on these certificates, wanted to come back, and Congress said the certificates were void and they couldn't come back. And the US Supreme Court upheld that decision in a case called Chai Chien-ping versus United States in 1889. And the rationale was that restriction of immigration from China was essential to the peace of the community on the Pacific coast. And again, what they meant by that is that the presence of Chinese induced white people to commit violence against them. And so the just solution to this problem was to exclude the Chinese. In this period, there was a recognition, I think, that the rationale for Chinese exclusion was that there were shared and ineradicable racial characteristics that had nothing to do with citizenship, nothing to do with birth in the United States, but that had to do with an essential nature of Chinese people. And so here are some of the things that were said in support of the Chinese Exclusion Act by members of Congress who voted for it. Alien in manners, servile in labor, pagan in religion, they are fundamentally un-American. Our civilization, which is the most potent in the world in blotting out race distinctions and amalgamating nationalities, is utterly powerless to efface in a single aspect the primeval national characteristics of the Chinaman. He is literally ironclad to the genius of our institutions. He is the same unadulterated Mongolian on the banks of the Sacramento River as he is on the Wangho. Another said, "It is not numbers that are needed. Quality is more important than quantity. One complete man, the product of free institutions and high civilization, is worth more to the world than hundreds of barbarians. Upon what other theory can we justify the almost complete extermination of the Indian, the original possessor of all these states? I believe that one such man as Newton or Franklin or Lincoln glorifies the creator of the world and benefits mankind more than all the Chinese who have lived, struggled, and died on the banks of the Wangho." United States versus Wong Kim Ark was a Supreme Court decision that had to decide whether Chinese born in the United States were citizens under the Citizenship Clause of the 14th Amendment. Citizenship Clause of the 14th Amendment provided that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Did that apply to Chinese? Well, the Department of Justice and some law review writers took the position that it didn't, that Chinese born in the United States were not citizens. The Supreme Court, 7-2, decided that they were, over the dissent of Justice John Marshall Harlan and Chief Justice Fuller. But the attitude of some people is reflected, I think, by the brief of the Solicitor General. The Solicitor General wrote to the Supreme Court, "For the most persuasive reasons, we have refused citizenship to Chinese subjects, and yet as to their offspring, who are just as obnoxious, and to whom the same reasons for exclusion apply with equal force, we are told that we must accept them as fellow citizens, and that too because of the mere accident of birth. There certainly should be some honor and dignity in American citizenship that would be sacred from the foul and corrupting taint of a debasing alienage. Are Chinese children born in this country to share with the descendants of the American Revolution the exalted qualification of being eligible to the presidency of the nation, conferred by the Constitution in recognition of the importance and dignity of citizenship by birth? If so, then verily there has been a most degenerate departure from the patriotic ideals of our forefathers, and surely in that case, American citizenship is not worth having." There was, in this period, I think, a recognition that the various racial groups in the United States shared some of the same basic problems. Obviously, the history and experiences of each were different, But I think there's some truth in this editorial from an African-American newspaper in 1892, which came out after a restrictive immigration law was upheld by the Supreme Court. And the editorial says the popular expression, "This is a white man's country," is an extension of Judge Taney's notorious dictum, "Negroes have no rights that the white men are bound to respect." As thus amplified, the dictum includes the Chinaman and Indian as well as the Afro-American, and the Chinese Exclusion Bill is an instance of its practical application. As immigration laws became more restrictive against Asians, so too did Jim Crow laws by the states. Asians were subject to many of the same kinds of limitations that other racial groups were, miscegenation laws, prohibiting marriage of Asians and whites, which was a particular problem because of the essential de facto prohibition of immigration of Asian women, beginning with the Page Act and then under the Racial Exclusion Acts. Asians were subject to restrictive covenants in owning land, both the immigrant generation and later. They were subject to school segregation like other racial groups. And they were also subject to a series of restrictions that were based on their inability to naturalize. 15 states, beginning with California, limited not non-citizens and not non-declarants, but aliens ineligible to citizenship, the racial category, from owning land. And there were many, many instances, other instances of white labor protectionism in this period. Terrace versus Thompson upheld limitations on Asian land ownership, and they did in an opinion that said essentially, look, if Congress has prohibited these people from naturalizing, there must be some reason. There must be some good reason that they're prohibited from becoming naturalized citizens, some reason about their undesirability. And if Congress says this, then the states can also use that classification to have their own discriminatory rules in other areas. So discrimination, as seems to happen in so many other contexts, justifies more discrimination. And a number of things follow. Prohibition on Chinese employment and things like the Sacramento City Charter. No Chinese shall ever be employed. The Reclamation Act of 1902 was a major public works provision that led to the construction of the Hoover Dam, among other things. And you probably can't read this dense text, but the last part is labor protection that labor unions managed to get in the bill. 8 hours a day shall constitute a day's work, and no Mongolian labor shall be employed thereon. By this point, we're not concerned about Chinese per se, it's Mongolians as a race. Madhavi, can I ask you how we're doing on time?
Well, if you could maybe wrap up in the next couple minutes, Jack, and we might be able to just throw a question or two at you.
Okay, so there's lots and lots of other details of the discrimination against Asian Americans in this period: taxes, licenses, rules, citizenship requirements designed to reserve the best opportunities for white labor. But the point that I want to leave you with is that this network of state and federal laws that was based on the idea that Asians are an undesirable addition to the American community worked. Asians are roughly 50% of the world's population. The United States is a nation of immigrants. And yet, as Asian exclusion was beginning to wind down, let's say in 1960, about 0.5% of the US population was Asian. The Indian problem, too, had been almost completely solved. And Latinx and African American citizens of this country were also subject to systematic regulation. And what I want to suggest is that a lot has changed, but many of the fundamental underlying circumstances that we were left with at the end of this systematic process of the systematic network of racially discriminatory rules has not been undone. We're still living with the consequences of it. I don't think there was anywhere in the United States in the 1960s, and I would be happy to be proved wrong, but I don't think that there was anywhere in the United States where people of color had a roughly equal, close to equal opportunity with respect to education, employment, housing, property ownership. And I think that some of the laws have changed, but as in the 1860s, the laws changed. But I am not sure that the nation changed its attitudes. And I want to leave you with this case, which was a decision of a unanimous Mississippi Supreme Court upholding the convictions of some freedom riders who had been attacked by a white mob. Their presence, the freedom riders who were trying to integrate segregated bus terminals, their presence induced violence against themselves. And white mobs attacked them. And the response of the police and the criminal justice system was to arrest the freedom riders and charge them with crimes. And as Chief Justice Taney explained the political conditions of the founding, the Mississippi Supreme Court explained the political conditions of the Civil War and after. And the punchline that I want you to see here is that they say, in affirming the convictions of the freedom riders for inducing violence against themselves, was that large numbers of people in this broad land are steeped in their customs, practices, mores, and traditions. In many instances, their beliefs go as deep or deeper than religion itself. And this is a startling claim in a nation where people assert that they are a religious people. On the other hand, maybe it's not so startling when so much of their property, education, employment, and status in society was associated with their race. I'll stop there. Thanks.
Yeah, that was just so amazing. Professor Chin, thank you for sharing this incredible history. I really wish we had more time. The fact that we had to skip some of your slides breaks my heart. And I know the people on the program with us today want to hear more. So I hope we can get you back. There were some questions in the chat, and one has come in from my colleague, Jerry Spann here at Georgetown. And he's asking this: based on the history you've described, Blacks and Asians should be natural allies in the quest for racial equality. However, as Black attacks on Asian convenience stores and Asian opposition to affirmative action suggest, this is not always the case. Do you have any suggestions for how we can promote Black and Asian racial solidarity? Thank you, Professor Spann, for that question. Professor Chin.
Thank you so much. I think African Americans, Asian Americans, Native Americans, Latinx Americans are natural allies with many, many white Americans who reject white supremacy. I think we're in the same boat. I think that what has happened is that at various points, the same groups of people who are trying in one context to subordinate one group, nevertheless try to leverage them, turn them against other groups. And so you see in the Reconstruction era, people saying, well, let's not let blacks vote because they're really not very smart. And we're if we're going to let anybody vote, it should be Chinese because they're way smarter. How could we justify letting blacks vote? And then some of those same people say, we really need to limit Chinese immigration because, a lot of these black people, they fought in the war, they're Americans, they're born here. How can we possibly justify letting Chinese come here and compete with blacks for jobs? And so the point is that this pitting racial groups against each other obscures what I see as the reality of the situation, that we're in the same boat. And you know what? It's an empirical question because maybe there's one racial group that could sell out other racial groups and advantage themselves. But I'm not sure I've ever seen that actually happen in reality.
Thank you. So, Professor Chin, I started by telling the story that my parents immigrated here in 1969, and I was born soon after. In your incredible history, I just was struck again by how my personal story is so much a product of the law. Asian exclusion to this country ended in 1965. I wouldn't have been an American citizen, but for the law changing just in the nick of time. I mean, and that's why I came here. But so, and just in terms of all of the analogies to 200 years ago and today, your image that you began with, the WASP image, I was so struck by the fact that the very arguments that were used against Chinese Americans in 1811, the effect on white labor, competition, but then also arguments around disease, right, are the very ones we're hearing the same epithets today. And more in the category of the more things change, for 20 points, before the Muslim ban was the Chinese Exclusion Act of 1882. So just thank you for just giving us that broader trajectory. But I wanted to just ask my one question about the breaking news today, right? The Senate overwhelmingly voted 94-1 to forcefully investigate hate crimes, particularly those against Asian Americans. And the question is just, what changes do you think we need to make legally and culturally to redress, for these redress efforts to be most successful, especially in light of this tragic history that you describe? I mean, what do we need to really do?
As I say, I think the bottom line is white supremacy. I think the fastest way for Asian Americans to improve their situation in society is to work with other racial groups. I don't think, given we are much larger than we were in 1960, than we were in 1970. And by the way, I think for the reforms of the 1965 Immigration Act, we have the African American civil rights movement to thank, among other people. Most Asians in the United States are descendants of post-1965 immigration, and I don't see how that would have happened without the sort of anti-racist efforts that took place in that period. And so I think, frankly, it's ungrateful of Asians to be attacking affirmative action at Harvard and other places now. But my if nobody has a solution, right? A clear, definite, sure solution to the question of racial equality. But what I think it is that I don't think that it's one group at a time. I don't think that there's some way for us to say, well, the situation of Latino immigrants, the situation of indigenous people, the situation of blacks, that's them and we're us, and we need to take care of us, and let's figure out how we can make sure our rights are protected and then, and they're on their own. I don't think that there's a way to do that, because the kinds of things that are hurting us now are based on these deep racial ideas, and they're not just about Asians. And as long as racial reasoning is considered legitimate in some contexts, then the Asian situation is different from these other groups. But nevertheless, there will be contexts where it comes back up and hits us, as it is happening right now.
Yeah, thank you. I want to thank you so much for these remarks. And it's now my honor to turn things over to our Dean of the Georgetown University Law Center, Dean Bill Traynor, who will offer some closing remarks on this wonderful program today.
Well, thank you very much, Dean Sunder. And this was extraordinary, Professor Chin. It was a tour de force account where you chronicled over 200 years of the history of violence and discrimination against Asian Americans in the United States. It was so powerful. And we are grateful to you for your enlightening history of Asian Americans' long battle for justice in this country. This story confirms that Asian Americans have helped build this country, from our physical infrastructure, including the railroads, to our legal infrastructure. And as you demonstrate, Asian Americans have helped establish the foundations of American constitutional law, from equal protection under the 14th Amendment to birthright citizen to civil liberties. Asian Americans have played at the forefront of legal battles for equality in the United States. Asian Americans have played a critical role in helping to expand notions of justice and belonging in our country. So, as I, was listening to your talk, I was reflecting on the words of Georgetown's President DeGioia. He said, "We are called to be in solidarity with our Asian American students, faculty, and staff, to affirm our care and support for one another, and to continue our work here at Georgetown to sustain a community that is inclusive, welcoming, and respectful of people of all backgrounds." So thank you again, Professor Chin, for sharing your wisdom with us tonight. And thank you to everyone who joined us for this important discussion. Take care and thank you all.